Hello everyone and welcome to today's video. I'm your host, Jason Applewatsit, with over a decade of family law experience, supporting over 10,000 families in that process. Today we aim to understand, we aim to understand the importance of the 1989 Children's Act and ask the question, did it really make a difference as to how men are treated in family courts? Before the Children's Act 1989 came into force in England and Wales, the legal framework governing the welfare of children when parents separated was very different and much more fragmented and disjointed. The primary laws and principles were governed by several statutes and common law precedents. The key legal framework before the Children's Act 1989 was the Guardianship of Minors Act 1971. This act primarily dealt with the parental rights and responsibilities, focusing on guardianship rather than the broader concept of parental responsibility. This was introduced a little bit later, emphasised the rights of the parents rather than the needs of the welfare of the children as paramount consideration. The Matrimonial Causes Act 1973, this act addressed the issues of divorce and the associated custody of children in that divorce, in that family. The court's primary concern was to often resolve the disputes between the parents rather than to focus solely on the child's welfare. Adoption Act 1976 governed the adoption process and consideration the welfare of the child in that specific context. The concept of custody and access. Now this concept, the legal terms custody and access were used, which often framed discussions in terms of ownership and visiting rights rather than the needs of the children. The Children's Act 1989 represented a fundamental shift in how the law, or was meant to, how the law approached the Children's Act, the welfare of the children in cases of parental separation. Now, the key changes included the paramountcy of the child's welfare. The welfare of the child became the paramount consideration in any legal proceedings involving the children. This represented a significant shift from the previous focus on parental rights and disputes. Parental responsibility, this was introduced the concept of parental responsibility, replacing the terms custody and access with residence and contact. This change emphasised the ongoing responsibilities of both parents, regardless of the marital status. The Act introduced the welfare checklist of factors that the courts must consider when determining a child's welfare, including the child's wishes and feelings, physical and emotional needs, and impact of any change in circumstances. Now, it also encourages the parents to reach an agreement through negotiation and mediation, rather than the adversarial court battles. Now, this introduced measures to facilitate cooperation between the parents for the benefit of the child. Now, the Act created a more cohesive and integrated framework for dealing with issues relating to children, consolidating and simplifying them from the previous legislation. The reasons for the changes were, a much more child-centric approach. There was a growing recognition that the previous legal framework did not adequately prioritise the welfare and the needs of children. The shift aimed to ensure that the children's interests were at the forefront of any legal decision making. The simplification and cohesion of the 1989 laws were seen as fragmented and inconsistent, leading to confusion and complexity within legal proceedings. The Children's Act 1989 aimed to create a unified and straightforward legal framework. Reflecting social changes, the Act was designed to reflect changing societal attitudes towards parenting, family structures, and the roles of mothers and fathers. It acknowledged the importance of both parents' involvement in the child's life, even after separation. The Children's Act 1989 Children's Act encourages a resolution outside of court. The Act sought to reduce several adversarial nature of family law disputes by promoting alternative dispute resolution methods. Overall, the Children's Act 1989 marked a significant evolution in family law, aligning legal principles with the best interests of the children, modernising the approach to parental responsibilities and rights. I think it's fair to say, though, however, that before the Children's Act 1989, there was a general presumption in practice that children would live with their mothers if their parents separated. This was England and Wales at least anyway. This presumption was influenced by several factors. The social and legal context pre-1989 was the tender years doctrine. Now, there was a prevailing belief that, often referred to as the tender years doctrine, which suggested that young children, especially infants and toddlers, were better off with their mothers. This was rooted in the assumption that mothers were naturally more suited to caregiving roles during their children's early years. Judicial attitudes. Judges and courts often operated under the assumption that mothers were the primary caregivers and thus more suited to have custody of the children. This led to a bias in favour of the mothers in custody arrangements. The legal language of the time focused on custody and access often framed the father's role as a visitation rather than shared parenting responsibility. Things haven't changed. Fathers were typically granted access rights rather than joint or primary caregivers. Societal norms and roles now played a massive part in this. Societal norms and gender roles at the time emphasised the mother's role in child rearing and the father's role as a breadwinner. This influenced both expectations of the parents themselves and the decisions made by the courts. Guardianship and the Minors Act 1971 and the Matrimonial Causes Act 1973. While these acts governed custody arrangements, they did not explicitly counter the prevailing societal and judicial biases towards mothers being the primary custodians of children. Impact of the Children Act 1989 is aimed to shift the focus on the child's welfare as the paramount consideration, moving away from the presumptions based on parental rights. Gender roles, at least in the mothers being the primary caregivers. This introduced the concept of parental responsibility, encouraging both parents to remain involved in children's lives and decisions regardless of the custody arrangements. This shift was intended to create a more balanced and child-centric approach to post-separation parenting, emphasising cooperation and the best interest of the child over traditional gender roles. This has not materialised, clearly. We need someone to take a step forward. Kafkas, do it. The courts need to do it.